Welcome to the next installment of the Weber Gallagher Workers' Compensation webinar series. I'm Robert Hanneman and this is Alan Arsenis, and today we're going to discuss permanency. We'll be going over partial total disability today. The issues of total disability and or Section 20 settlements will be covered in other webinar series. They're full topics. I don't think we need to cover all three of them today, so we're just going to focus on the partial total disability resolutions.
Good afternoon, ladies and gentlemen. I just want to start off by providing the statutory definition of permanent disability. That's found in Section 36 of the Workers' Compensation Act, and to read it, it says, disability permanent in quality and partial in character, which means a permanent impairment caused by a compensable accident or compensable occupational disease based upon demonstrable objective medical evidence which restricts the function of the body or of its members or organs. In establishing that, you also have to demonstrate a lessening to a material degree of workability or restrictions in ordinary pursuit of life, such as used to bowl before this accident, I can no longer bowl, used to golf, I can no longer swing a golf club, used to be an avid weight trainer, but I can't do that anymore because my back hurts. Examples such as these.
With regards to this, the court has established this under case law. The seminal case that's involved is the Perez versus Pantasote. It's 95 NJ 105. It's a Supreme Court case from 1984, and this is the case that confirms the two-pronged test that Alan just discussed. You have to be able to show that they have a demonstrable medical evidence of a loss, as well as a loss of function in order to establish a permanent disability. There is no established threshold for a permanent disability. The next case of Cologne versus Coordinated, this is also a Supreme Court case from 1985, indicates that the Section 36 does not establish a threshold percentage of disability for minor injuries. A minor injury, if it meets the criteria of Perez, can be resolved for 1% of either a partial total disability or of the affected body part. With regards, and now we're talking about the disabilities, with regards to a percentage of disability, the calculations can be done either based on a specific body part or on a partial total basis. And it depends on the functional loss and what actual body part was injured. With regards to this, we, as you see on your screen now, there's a schedule of disabilities in New Jersey. I understand it's very small print, so it's hard to read. So if there's anybody out there who needs a full and complete copy of the schedule of disabilities, please contact us after the webinar and we'll make sure we provide you with a clearer copy. But what happens with the schedule of disabilities is the individual body parts are broken down, and I understand it's difficult to read on the chart, but it's broken down for your hand separately from your arm, which is separately from your foot, your leg. The overall partial total disability involves any of the major torso area of your body, your head, your neck, your shoulders, your back, and all internal organs all the way down to your hips. The schedule of disability, what you do is you find a percentage of disability for that particular body part, and this gives you a number of weeks for the disability and a dollar figure. The way the dollar figure is calculated is on the second page of the chart, and as you can see, it's a graduated scale until you hit over 180 weeks. Typically referred to that as the 30% hump. After that 30%, all weeks are paid at the exact same rate. Prior to that, it's paid on a graduated scale. So you'll see when you receive recommendations by counsel or you receive orders, sometimes there's a calculation of an unusual dollar figure when you're resolving a case for 20% of partial total disability or 25 or 30% of the leg, because what we do is we average the dollar figures to be paid the same amount each week. Instead of paying the first 90 weeks at the $1 figure and then paying every 6 weeks a different dollar figure, we do an average calculation per the court's recommendations.
Now, we all know that when it comes to permanency, we're always looking for a credit against whatever we ultimately have to pay. Section 12D of the Act establishes that we're entitled to a credit for a prior functional loss. Not just an injury, but we have to prove some type of prior functional loss of ability to function as a normal person. There are different examples of that. For instance, we often refer to prior credits as an Abdullah credit. Where the case law of Abdullah versus S.B. Thomas established that anytime there's a prior award for the same body part, we're entitled to a dollar-for-dollar credit. So oftentimes when we set up a file, we'll give you an estimate of overall exposure, and we'll say that we're going to look through the Department of Labor to see if there's any prior awards. We find a prior award that establishes a dollar-for-dollar credit. For example, if we ultimately have to pay a 40% of partial total for low back injury, but the person has a prior award of 25% for prior low back injury, that gives us an absolute credit for the 25% previously paid. There's no negotiations in that respect. There are also other types of credits out there which are pre-existing conditions. For instance, a prior congenital condition that limits a person's functional capabilities, or even a prior motor vehicle accident that's not work-related. Another good example is the prior motor vehicle accident where someone injures their back and has surgery. Under workers' comp scenario, we would get a percentage credit established by the prior award, but in this instance, there's no prior award because it was non-compensable, it was not work-related. So that has to be negotiated. Oftentimes, we try to get the same credit as we would if there was a prior award, but it doesn't always work out that way. It's more left up to the negotiation process.
Again, with regards to the credit, we have to establish that there was a pre-existing disability. Just because petitioner may have noted some complaints to a doctor 12 or 14 years ago, that may not necessarily establish a pre-existing disability, although there may have been pre-existing issues. We have to meet the same standards that the petitioner has to meet with regards to permanent disability when we're trying to establish the criteria for a credit. And remember, it is the respondent's responsibility to present the information with regards to a credit. A lot of times the only information we get with regards to a credit comes directly from the petitioner. If they haven't provided us accurate information, we need to take all diligent steps to investigate whether or not there's pre-existing disabilities, whether or not there was prior complaints, whether or not there was prior diagnostic studies. This is why we request prior case files from the state. This is why we request ISO reports and prior medical records.
That is correct. Just like they have to prove a prior functional loss, we have to prove the same for a credit. When we're establishing an overall exposure potential, we have to take into consideration what they call stacking. Oftentimes, a single accident at work will result in multiple injuries, perhaps an arm, a leg, a hip, back. And the case law, Pazwitowski versus Standard Chlorine Chemical Company, establishes the theory and the law that says you must stack all the body parts into a partial total category when you have two major members or more. So for instance, if you have a right arm and a left leg, or two major members, it has to be stacked into partial total. At the same time, the case of Ventry versus CPC International says you don't just add up all the numbers of the various different injuries and come to an overall value. You have to do that and then take a step back and look at the total person and determine what their overall disability is as a functioning unit. So oftentimes we'll start with adding the numbers and then we back them out once we determine, well, this case isn't really worth 80% of total just because he has 17 injuries. It's worth 45 when you look at the whole person. And that's what that case establishes.
Some of the criteria you'll also look at when you're determining the permanency with multiple body parts is, has the petitioner returned back to work? Did they go back to the same job doing the same duties? Did they return back to work full duty? Did they return back to work with limitations? What's their lifting limitations? Maybe petitioner has changed jobs and now has a lesser physically demanding job. These are all factors that the court will take into consideration, as well as counsel, when we're talking about establishing a permanent disability number for the petitioner.
Absolutely. And in fact, sometimes we'll have a disparaging difference between ages. For instance, a younger gentleman can rebound from a low back injury and go back to work with minimal functional impairment, where an elderly person is going to have a much more devastating effect. So these are factors that we just have to take into consideration when we're trying to establish an overall exposure potential and obviously a reserve for the file.
One of the topics we want to cover with regards to this is always expect the unexpected. Some of the additional issues that come up either during treatment or as a result of diagnostic studies and testing could have a significant effect on an overall permanency rating and a permanency resolution. With regards to this, one of the more significant factors that keeps coming up is a diagnosis called RSD. It's also called CRPS. It's a neurologic condition. Typically, it happens with an injury that is resulted on a limb, such as a foot or a hand, and there seems to be disproportionate neurologic pain or symptoms in the body part that the doctors just can't seem to identify. 10 or 15 years ago, when I first started doing this, and then again another 10 years before Alan started doing this, RSD wasn't a go-to diagnosis. It was a last-ditch diagnosis. If the doctor couldn't find any other reason as to why petitioner's pain was still so high and he was still having or she was still having the complaints, then they went to an RSD diagnosis. But in more recent years, as soon as petitioners making disproportionate complaints and pains to an affected body part, it seems like the doctors are more willing to jump to this RSD slash CRPS, or referred to as CRIPS, diagnosis. Another issue that comes up is petitioners undergone one-level back fusion surgery, and either because of the fact that they're morbidly obese or they continue to smoke throughout the whole procedure, they've now developed what's called a failed back syndrome or a post-laminectomy syndrome. This results in either a non-union of the fusion or disproportionate pain and symptoms ongoing after the fusion. One of the other diagnoses you may hear is called arthrodesis. Even though petitioner has had back fusion surgery and the underlying issue has been treated, this may result in a greater overall disability because of the failed situation with regards to the back. Because petitioners sometimes don't have positive results as a result of authorized treatment or even unauthorized treatment, they develop ongoing psychiatric issues that are the result of their chronic pain. Petitioners will become depressed if after multiple months or even years of ongoing pain that just does not seem to be resolved as a result of their ongoing treatment. Anxiety is also an ongoing issue with regards to petitioners that we see a lot in the medical records. Many times it's not pled by petitioner's counsel, and we don't address same if it's not brought up by counsel. It's their obligation to bring forward all allegations. It's not our job to pay petitioner additional money for any allegation they haven't brought in the claim petition.
And if I may interrupt for a moment, these are factors that are extremely important to take into consideration because these unexpected factors that we just mentioned have a dramatic impact on the value of the case. I've had many cases where RSD results in total disability. Failed back syndrome, I've had maybe 9 over the past 24 years of doing workers' comp, where 8 out of the 9 resulted in total disability. And unfortunately, when you have such a significant condition that develops, even though we try to bring in the fund for contribution, oftentimes the fund takes the position, failed back syndrome in and of itself results in total disability, therefore they do not contribute, much like RSD. So these are the conditions, even chronic pain syndrome or depression, that could have a significant impact on the value of the case, and you find that you alone are paying for all of it because in and of itself these conditions can total you out. So these are the type of key words that when you see them, set up the red flag because that means the value of the case is going to dramatically skyrocket.
Now these are all issues that directly affect the petitioner with regard to his medical care. There's other factors with regards to permanent disability and determination on what a case and value is worth that are not related to petitioner specifically, but have to do with either the judge or petitioner's counsel. Sometimes you'll deal with a petitioner's counsel that you've dealt with on multiple occasions, you've got a good relationship with, and therefore negotiations go fairly well, fairly quickly, and you're able to reach a meeting of the minds to resolve the case. There's other times where you have a petitioner's counsel who normally does personal injury work, is, well, for lack of a better term, carpetbagging and workers' compensation because he took a case because he wanted the underlying motor vehicle accident part of the case, and is looking to get top dollar on both of his cases. He'll make an unreasonable demand, thinking that it's similar to a personal injury case, and isn't willing to negotiate with regards to that, and sometimes that means we need to get the court involved with regards to conferencing the case. One of the problems we have with having the court get involved is each judge is different. On the screen you'll see we reference the judges as liberal and conservative. They vary in a wide variety of venues and things like that. I do more work in the South Jersey area. The judges down in Atlantic City are known to be just a little bit more liberal. While they're fair-minded and very well versed in the law, they do seem to be a little bit more liberal in their approach with regards to permanent disability. And I need to take that into consideration when I'm making a recommendation to my client for reserves or when I'm negotiating with counsel in an effort to try to reduce the carrier's exposure, because that's our main goal. We want to reduce the carrier's exposure to the best of our ability.
And in some instances, when we do our initial analysis of potential exposure, we'll comment that, oh, this is listed in freehold or in front of such and such judge, and we give you a range that's greater than the expected range for that injury based solely upon the venue and the judge, if the judge is liberal. Also, another factor could be your adversary. Some of them are a lot more aggressive. Some of them are very easygoing and come in with a demand that is under what you expect. Obviously, we'll want to take advantage of that when we can, but oftentimes we find ourselves fighting against the more liberal and demanding adversaries who they don't care if a typical operated low back herniation with good results is 25. They're looking to get over the hump, and those are the cases that go to trial often because there's no way of reasoning with these people. But you don't want to take that to trial in front of a liberal judge such as Judge Mulvaney in Tom's River, because he's extremely liberal. He'll easily find a basis to go over the hump. So it is a lot of factors that will come into play that you have to find ways to work around those factors and still maintain a reasonable value so that everyone can be happy at the end of the day.
As you can see on the screen, one of the comments we want to just make before we close out is the relationships with the court and petitioner's counsel are important. We try not to burn bridges. We're not going to give away the farm with regards to any settlements. Our job is to reduce our carrier's exposure to the best of our ability, if possible, to resolve a case via Section 20 so there's no further responsibility on behalf of the carrier for that particular claim. But there is a lot of negotiations that go on, especially with petitioner's counsel as well as with the judge in the court. And while we will be and we continue to be aggressive in all of our cases and all of our handlings, we have to make sure that we're not burning bridges also. Petitioner's counsel will tend to hold things against you if you were able to successfully defend a case where he felt he was in the right, and from further on, we'll run into difficulties dealing with that counsel later on. Hopefully that doesn't happen in most of our venues, as negotiations are usually pretty straightforward.
And in that respect, judges can be very vindictive. So you have to keep a strong relationship with the judge that you appear in front of on a regular basis, so that you can, A, get them to be reasonable in the high exposure claims, and at the same time know that, okay, judge, I got to try this case. And you know in the back of your mind he's liberal, but you try to get that point across. Judge, try to be reasonable here. Don't go crazy. I don't burden your list with a lot of trials. I try to resolve cases. I'm always reasonable. And these are the things that you try to develop with your judges, a different relationship, so that when you have to try your case, he's not looking for a reason just to throw the money away.
Here at Weber Gallagher, we have two offices that cover the entire state. And each of our counsels, each of our attorneys handle specific jurisdictions. I mostly handle South Jersey, as I indicated before, being in Atlantic City and Camden and Mount Holly. Alan handles a little bit more of the central part of the state, being Freehold and Tom's River. Because of that, we get to know our judges. We get to know the players in each of those venues, and that helps us with our abilities to negotiate with those parties. One of the last things that I want to comment about is each judge is different. Some judges will make a recommendation, and if the parties agree to that recommendation and resolve it, fine. Some judges will allow you to differ from that recommendation if the parties are in agreement. As long as the parties are in agreement, the court will put through the settlement. There are other judges in different venues that once the court makes the recommendation, if the parties are not agreeing to that dollar figure or that percentage of disability, the matter will be tried. Some judges will do partial trials on the issues of liability only. Other judges will try the entire case, wanting an entire schedule set up for all doctors and all parties, and try the case to conclusion without any further conferences or recommendations for resolution. So knowing the judge and opposing counsel can go a long way with helping you resolve the case.
Absolutely. In fact, there are some judges that if you don't take their recommendation, they hold that against you at trial. And at the end of trial, instead of paying what they had suggested initially, you're paying considerably more. So And those are the judges that will warn you about when we cross their paths. For those who are interested, we have some upcoming webinars in the future. July 18th, Considering Medicare's Interest. That will be presented by Mark Gallagher and David Assalone from our Philly office. August 15th, Temporary Total Disability, Defenses to the Obligation to Pay. That's presented by my cohort here, Robert Hahnemann and Jennifer Laver. And on September 19th, come on down, The Price is Right, Settling Your Workers' Compensation, easy for me to say, compensation case for the best value. Again, September 19th by James Basili. Also a couple more, October 17th, You Can't Always Get What You Want, presented by Joe Baruch and Vanessa Medjalewski. And finally on November 14th, Defining Injuries in Pennsylvania Comp Courts by Jeffrey Seafried and Lucas Kozalowski. One more. December 19th, Top 10 New Jersey Workers' Compensation Cases of 2017, presented by Mark Sotero and Cheryl Benosa. I hope you found this webinar to be useful, insightful, and informative. And if you have any questions, feel free to contact us at the contact information on the first page of the webinar materials. Thank you, and have a great day.
Thank you. Have a good afternoon.